My name is Katherine Walsh, and I'm 74 years old. I spent my entire career as an international law professor at Columbia University, teaching courses on war crimes tribunals, international justice, and the legal frameworks that govern armed conflict. For 40 years, I told my students that the Nuremberg trials established the foundation for modern international criminal law, that they proved it was possible to hold individuals accountable for crimes against humanity, even when those individuals had been acting as state officials. I believed every word of that narrative. Then last year, I discovered documents that revealed the first Nuremberg trial was almost derailed before it began, and the real story of how it survived those crucial early days would fundamentally change how we understand the birth of international justice. It started when I was contacted by the grandson of Justice Robert Jackson, the American prosecutor at Nuremberg. His name was Michael Jackson, a lawyer practicing in Philadelphia, and he'd been sorting through his grandfather's personal papers, materials that had never been donated to official archives. Among those papers, he found a series of private letters and diary entries from the months leading up to the trial, documents that painted a very different picture of the proceedings than the triumphant narrative I'd been teaching. Michael invited me to his home to examine the materials. Sitting in his study on a cold January afternoon, surrounded by boxes of yellowed papers and fading photographs, I began reading Justice Jackson's private thoughts about the trial. What I discovered shocked me. The first Nuremberg trial, the landmark proceeding that prosecuted major Nazi war criminals, had nearly collapsed multiple times before it even began, and the reasons had nothing to do with legal technicalities or evidentiary challenges. The crisis was political, driven by fundamental disagreements among the Allied powers about what justice should look like. According to Jackson's diary entries from June and July 1945, the British initially opposed holding trials at all. Winston Churchill and significant portions of the British government favored summary execution of top Nazi leaders, arguing that trials would be show proceedings that lacked legitimacy and would give defendants a platform to spread propaganda. Churchill specifically advocated for identifying the top 50 Nazi leaders, declaring them guilty by executive decree, and executing them within 6 hours of capture. The Soviet position was equally troubling, but from the opposite direction. Stalin wanted trials, but trials with predetermined outcomes. Soviet representatives made it clear they expected convictions and death sentences for all defendants, and they saw the proceedings primarily as a tool for demonstrating Allied unity and German guilt, not as a genuine legal process. The idea of acquitting anyone, or even allowing robust defense, was anathema to Soviet legal philosophy. The French, still reeling from occupation and desperate to reassert their status as a major power, were caught between supporting their British allies and pursuing their own agenda of maximum punishment for Germany. They wanted trials, but trials focused specifically on crimes committed in France, with French judges playing leading roles. Only the Americans, led by Justice Jackson, consistently advocated for genuine legal proceedings with proper standards of evidence, rights for defendants, and the possibility of acquittal if evidence was insufficient. Jackson believed passionately that establishing precedent for international law required actual justice, not victor's justice disguised as legal process. The tension came to a head in late July 1945 at a meeting in London where representatives of the 4 Allied powers were attempting to draft the charter that would govern the trials. Jackson's diary entry from July 26th described a meeting that almost ended the entire endeavor. The British representative had proposed language that would have made the tribunal's judgments essentially immune to any appeal or review, with convictions based on moral certainty rather than legal evidence. The Soviet representative supported this, adding that defendants should not be allowed to claim they were following orders or acting in official capacity as defenses. Jackson had erupted. According to his diary, he'd told the assembled representatives that what they were proposing wasn't justice, it was revenge dressed in legal robes. He'd argued that if the Allies wanted to execute Nazi leaders, they should do so honestly as an act of war, not create a mockery of legal process that would discredit international law for generations. His exact words, preserved in his diary, were, "If we're not going to offer genuine due process, then we shouldn't pretend we're offering justice. History will judge us not just on whether we punish the guilty, but on whether we do so through a process that has moral and legal legitimacy." The meeting had ended in deadlock. For 3 days, the entire Nuremberg project hung in the balance. The British and Soviets discussed proceeding without American participation. The Americans considered withdrawing entirely and pursuing their own process for defendants in their custody. The fragile Allied unity that had won the war was fracturing over how to judge the defeated enemy. What saved it, according to Jackson's account, was a private conversation with the British representative, Sir David Maxwell Fyfe. Jackson and Maxwell Fyfe met for dinner on July 29th, without Soviet or French representatives, and had a frank discussion about what was really at stake. Maxwell Fyfe admitted that Churchill's position was driven partly by fear that trials would be too lenient, that clever German lawyers would exploit legal procedures to escape justice or mitigate punishment. Jackson had responded by proposing specific procedural safeguards that would prevent abuse while still maintaining legitimacy. Defendants would have lawyers, but the prosecution would have access to vast documentary evidence that the defense couldn't match. Rules of evidence would be relaxed compared to standard criminal trials, allowing hearsay and documentary evidence that might not be admissible in peacetime courts. The tribunal would be composed of judges from all four Allied powers, but they would decide cases based on evidence presented, not on predetermined political outcomes. Most importantly, Jackson proposed that the trial focus on documentary evidence rather than witness testimony wherever possible. The Nazis had been meticulous record keepers, documenting their crimes in extraordinary detail. By building the prosecution case primarily on German documents, orders, and official records, the trial could prove guilt beyond any reasonable doubt, while avoiding the circus of conflicting witness accounts that Churchill feared. Maxwell Fyfe had been intrigued. Over several more days of private discussions, he and Jackson crafted a compromise framework that they then presented to the full Allied Commission. The framework preserved the appearance of legal process that Jackson insisted on, while incorporating enough controls and procedural advantages for the prosecution that the British and Soviets felt confident of achieving convictions. It wasn't perfect justice, but it was workable justice enough to proceed. The London Charter was signed on August 8, 1945, establishing the legal framework for the International Military Tribunal at Nuremberg. But according to Jackson's papers, that was just the first crisis. The second came during the selection of defendants and the preparation of indictments. The Soviets wanted to include German industrialists and financiers who'd supported the Nazi regime, seeing the trials as an opportunity to prosecute capitalism as much as Nazism. The Western Allies resisted, concerned that such an approach would blur the lines between political show trial and legitimate legal proceeding. The compromise was to focus the first trial on military and political leadership, with potential future trials for other categories of defendants. Then there was the question of Soviet crimes. Jackson's diary entries from September 1945 reveal that he'd wanted to include charges related to the Soviet invasion of Poland in 1939 and the Katyn Forest massacre, where Soviet forces had executed thousands of Polish officers. The Soviets absolutely refused, threatening to withdraw from the proceedings entirely if their wartime conduct was subjected to any scrutiny. The Western Allies, still needing Soviet cooperation in occupied Germany and concerned about the emerging tensions that would become the Cold War, backed down. "We're prosecuting wars of aggression and crimes against humanity," Jackson wrote in his diary on September 14th, "but we're excluding from consideration the Soviet invasion of Poland, which was just as much a war of aggression as the German invasion. We're prosecuting crimes against prisoners of war, but we're not examining Katyn. The hypocrisy is obvious, and it will undermine the legitimacy of everything we're trying to achieve. But the alternative is no trial at all, and I've decided that imperfect justice is better than no justice." I found this deeply troubling. The Nuremberg trials were held up as the gold standard of international justice, the moment when the world said never again to atrocities and established that individuals could be held criminally responsible for state-sanctioned crimes. But the foundation was compromised from the beginning, built on political expedience and selective prosecution. As I continued reading through Jackson's papers, the picture became more complex. Despite all the political compromises and procedural irregularities, Jackson had genuinely tried to create a fair process within the constraints he faced. He'd insisted on competent defense counsel for all defendants over Soviet objections. He'd allowed defendants to testify in their own defense, to call witnesses, to cross-examine prosecution witnesses. He'd built the prosecution case on documentary evidence that was genuinely damning, German records that proved beyond doubt the systematic nature of Nazi crimes. The trial itself, which began in November 1945, became something neither pure legal proceeding nor pure political theater, but rather a hybrid that somehow worked. The documentary evidence was overwhelming. Orders for mass executions, records of concentration camp operations, minutes from meetings where the extermination of European Jews was planned and coordinated. The defendants couldn't deny the documents' authenticity. They'd signed them, issued them, implemented them. But Jackson's papers also revealed moments of doubt and frustration throughout the trial. In January 1946, he wrote about watching Soviet Judge Nikitchenko vote mechanically for conviction on every charge, regardless of evidence. In March, he described his anger when British prosecutors tried to introduce evidence about the bombing of Coventry as a war crime, while refusing to allow any discussion of Allied bombing of German cities. In April, he expressed disgust at watching some defendants clearly guilty of monstrous crimes exploit procedural protections he'd fought to include, using the legitimacy of the process to create doubt about their culpability. The most revealing entry came from October 1946, just days before the tribunal announced its verdicts. Jackson wrote, "Whatever we've created here, it isn't pure justice. It's victor's justice, dressed in legal procedure and constrained by rules we imposed on ourselves. But perhaps that's still progress. Perhaps establishing the principle that even winners in war must follow some rules, must provide some process, must allow some defense, is enough. Perhaps perfect justice was never possible, and demanding it would have left us with nothing at all." The verdicts announced on October 1, 1946, reflected all these compromises and contradictions. 12 defendants were sentenced to death, 3 to life imprisonment, 4 to terms of 10 to 20 years, and 3 were acquitted. The acquittals particularly outraged the Soviets, who'd expected convictions across the board. But those acquittals, Jackson believed, were what gave the trial whatever legitimacy it had. The fact that the tribunal had actually weighed evidence and found some defendants not guilty proved it hadn't been a complete show trial. After reading through all of Jackson's papers, I spent months tracking down additional sources. I found minutes from Allied planning meetings in British archives, correspondence between Soviet officials in Russian archives recently made accessible, French diplomatic cables discussing the trial preparations. Every source confirmed Jackson's account. The first Nuremberg trial had been a near miracle of diplomatic compromise, legal improvisation, and political navigation. I also interviewed the few remaining people who'd been involved with the trials in supporting roles. A 97-year-old former translator described the tension between Soviet and Western Allied personnel. A 94-year-old clerk who'd worked for the defense team described how German lawyers had initially been skeptical that they'd be allowed to mount genuine defenses, and their surprise when they were actually given access to documents and witnesses. A 98-year-old journalist who'd covered the trial described the electric atmosphere in the courtroom when documentary evidence of atrocities was presented, the way even hardened reporters had been shaken by the material. What emerged from all this research was a more nuanced understanding of Nuremberg. It wasn't the purely noble proceeding I'd been teaching about, but it also wasn't the complete sham that some critics had claimed. It was something in between, a genuine attempt to create legal accountability for unprecedented crimes, constrained and compromised by political realities, but still representing real progress in international law. I decided to write a comprehensive article reassessing the first Nuremberg trial, incorporating Jackson's papers and the other materials I'd discovered. The article, titled "Imperfect Justice: The Political Compromises Behind the First Nuremberg Trial," was published in the Yale Law Journal in September. The response was immediate and intense. Some colleagues praised the work as important historical correction, acknowledging that our understanding of Nuremberg had been overly sanitized. Others criticized me for undermining faith in international justice institutions, arguing that revealing the trial's compromises and contradictions would give ammunition to those who wanted to discredit international criminal law entirely. The criticism stung, but I believed transparency was essential. Students of international law needed to understand that even landmark proceedings like Nuremberg were products of their time, shaped by political pressures and practical constraints. Understanding those limitations didn't diminish the trial's importance. It actually made their achievements more impressive. Despite all the obstacles and compromises, the Nuremberg trials had established crucial precedents. that individuals could be held criminally responsible for state crimes, that following orders wasn't an absolute defense, that wars of aggression and crimes against humanity were punishable under international law. In November, I was invited to speak at a conference in The Hague, home of the International Criminal Court. Standing before an audience of international lawyers, judges, and human rights advocates, I presented my findings about the first Nuremberg trial. I talked about the political battles, the compromises, the moments when the entire proceeding almost collapsed. But I also talked about what had been achieved despite all those challenges. Justice Jackson knew he wasn't creating perfect justice, I told the assembled lawyers. He knew the proceedings were compromised by political necessity, by selective prosecution, by the fundamental inequity of victors judging the vanquished. But he also understood that establishing any framework for international accountability, however imperfect, was better than establishing none at all. He was willing to accept imperfect justice because the alternative was no justice. A judge from the ICC raised her hand. Professor Walsh, doesn't acknowledging these compromises undermine the legitimacy of the precedents Nuremberg established? If the first trial was so politically motivated, why should we treat its legal findings as binding? It was the core question, the one I'd been wrestling with throughout my research. Because legitimacy doesn't require perfection, I responded. The Nuremberg trials were imperfect, but they were still unprecedented. For the first time in history, leaders of a defeated nation were held individually accountable for their crimes through a legal process, not just executed as an act of war. Yes, it was victors' justice. Yes, there was selective prosecution. Yes, political considerations influenced procedures and outcomes. But within those constraints, genuine legal work was done. Evidence was presented and evaluated. Defendants were allowed to mount defenses. Some were acquitted. That was progress, real progress, even if it wasn't perfect justice. The conference discussions continued for 2 days, with scholars and practitioners debating the implications of my findings. Some argued that we needed to be more honest about the political dimensions of international justice, that pretending tribunals are purely legal proceedings rather than legal political hybrids creates unrealistic expectations. Others contended that acknowledging political influences risks legitimizing political interference in judicial processes. What became clear through these discussions was that the tensions present at the first Nuremberg trial persist in modern international criminal law. The International Criminal Court faces similar challenges, questions about selective prosecution, concerns about victors' justice, debates about balancing legal principles with political realities. Understanding how those tensions played out at Nuremberg, how Jackson and others navigated them, offered lessons for contemporary practitioners. In December, I received a letter from a former prosecutor at the International Criminal Tribunal for the former Yugoslavia. He thanked me for the article, saying it had helped him understand challenges he'd faced during the Balkans trials. "We were always told that Nuremberg was the perfect model," he wrote, "that if we just followed their example, we'd achieve justice. But Nuremberg wasn't perfect, and trying to live up to an idealized version of it created unrealistic expectations. Understanding that even the first international tribunal faced political pressures, made compromises, and still achieved something worthwhile, that's liberating. It means we can be honest about our own limitations while still doing meaningful work." That letter crystallized something important for me. By sanitizing Nuremberg's history, by presenting it as an uncompromised triumph of justice over politics, we'd actually done a disservice to international law. We'd created an impossible standard that no real-world tribunal could meet. Better to understand Nuremberg as it actually was, a flawed but important first step, a proceeding that established crucial precedents despite political constraints, a model for how to pursue justice even when conditions are far from ideal. I revised my teaching materials completely. When I returned to Columbia in January, my course on war crimes tribunals began with an honest assessment of Nuremberg's strengths and weaknesses. I taught my students about Jackson's struggle to maintain legal legitimacy in the face of political pressure. I explained the compromises that were made and why they were made. I showed them how the trial succeeded despite its flaws, and what lessons that offered for modern international justice. The student response was remarkable. Rather than being disillusioned, they seemed energized by understanding the real history. One student told me, "It's more inspiring to learn that they faced all these obstacles and still created something worthwhile than to believe they had perfect conditions and just had to execute a plan. It shows that meaningful work is possible even when circumstances are far from ideal. In March, the US Holocaust Memorial Museum asked me to develop an exhibit on the Nuremberg trials that would incorporate the new historical understanding my research had revealed. Working with museum curators and historians, we created a display that didn't shy away from the trial's political dimensions while still honoring their achievements. We included Jackson's diary entries, showed the internal debates among Allied powers, explained the compromises that were made, but also presented the documentary evidence that proved Nazi crimes and the legal precedents that were established. The exhibit opened in June, 79 years after the London Charter was signed. At the opening ceremony, I stood before a reproduction of Justice Jackson's opening statement at the trial, his famous words about how the wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Those words remained powerful, remained true, but now I understood the context in which they were spoken. A moment of profound uncertainty, when the entire proceeding might collapse, when political pressures threatened to derail genuine justice, when Jackson and others fought to maintain legal legitimacy against enormous obstacles. Understanding that context didn't diminish the words, it gave them greater meaning. Michael Jackson, Justice Robert Jackson's grandson, attended the exhibit opening. We stood together looking at his grandfather's diary entries, displayed under glass for visitors to read. He would have wanted people to know the full story, Michael said quietly. He wasn't trying to hide the difficulties or pretend everything was perfect. He documented all the challenges because he understood that future generations would need to learn from both the successes and the failures. That evening, I reflected on what I'd learned over the past year. The first Nuremberg trial hadn't been the flawless proceedings I'd been teaching about for 40 years. It had been messy, political, compromised, and imperfect, but it had also been genuine, important, and precedent-setting. Justice Jackson and his colleagues had faced impossible circumstances and created something worthwhile despite all the constraints. The trial changed everything, not because it was perfect, but because it happened at all. It established that international crimes could be prosecuted, that individuals could be held accountable, that even in the aftermath of the most destructive war in history, legal process was possible. Those achievements were more impressive, not less, when understood in the context of the political battles that nearly prevented them. As I revised my textbook on international criminal law, incorporating the new historical understanding, I realized that this was the lesson students most needed to learn. Justice is never achieved in ideal circumstances. Legal proceedings are always influenced by political realities. Perfect impartiality is impossible when judging conflicts between nations and peoples. But none of that means we shouldn't try. The first Nuremberg trial, with all its flaws and compromises, proved that pursuing justice despite imperfect conditions can still produce meaningful results, can still establish important principles, can still represent progress toward a more accountable international order. Judging Germany changed everything, not because the trial was perfect, but because it demonstrated that judgment was possible. Not because politics were absent, but because legal principles could be maintained even amid political pressures. Not because it achieved pure justice, but because it established that even imperfect justice was better than no justice at all. Justice Jackson understood that. He fought for it, compromised when necessary, and created something that, despite all its flaws, laid the foundation for modern international criminal law. That foundation remains relevant today, in an era of new international courts and tribunals, new debates about accountability and justice, new tensions between legal principles and political realities. Understanding how that foundation was actually built, understanding the struggles and compromises that went into creating it, doesn't undermine it, it strengthens it. It shows that meaningful progress is possible even in difficult circumstances, that principles can be maintained even under pressure, that the work of justice is always imperfect, but always worthwhile. The first Nuremberg trial changed everything. Now finally, we understand how.